can bring out Mr. Bradley. The issue that we were going to address this morning was the state's request for a jury instruction on diminished capacity. Is the state ready to proceed on that?
Yes.
Okay, you may do so.
I may approach.
Yes, you may.
We agree. I agree with that.
You agree with this except for what?
I agree with it. Now that the state has added a word, knowingly. So that's it. I haven't put a bid in it. So, Judge, my only issue with that is the jury instruction doesn't include the term knowingly. I know the experts use it, but I went back, when I created this, I went back to the jury instruction. And it says, if you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. And in the first paragraph, such a statement should always be considered with caution and weighed with great care to make certain it was freely and voluntarily.
I mean, you're talking about the jury instruction to the voluntary statement, voluntariness of the statement.
Yes.
Okay.
So, and that's why I put that in the last sentence of what he's referring to. What I put is such evidence is to be considered by you only for the purpose of determining whether the defendant's interview was freely and voluntarily made.
Statements. And I would add to that even jury instructions don't always get it right. You don't always track the law, and I didn't the case in hand today, I know that first thing this morning, but the cases, what I say, it's going to be freely, voluntarily, and knowingly given. So I mean, that's what the case is whole. So instruction is 2 out of 3 words, then the important is not bound by the instruction, not by what the case is saying. That's how it's determined. That's how it's analyzed by the courts. Now, can I hand the court the case right now? I cannot, but I can have one in about 2 minutes of research. The instruction should track the law.
Response from the state as to adding the word "and knowingly."
Judge, even in your discretion, I simply extract the instruction the way that it's written, that this one is promulgated, and that this is the statement. So.
Ms. Ashley, are we looking that up? Okay, we should have the case one way or another in just a few moments. I see says request for compulsory judicial notice.
Yes, ma'am. I've given a copy of that to around. That's court to take notice of matters which are readily ascertainable or cannot be disputed. And one fact, paragraph 1, the defender was appointed, Representative Bradley, of the appearance of p.m. And we would not statutorily authorize to take action on his behalf in the case prior to that. And the second matter in paragraph 2 is that a court order is necessary to take a blood sample from the defendant. So, we're talking about matters which are readily ascertainable, can't be disputed, shouldn't be, but those are not the state of affairs, and it helps the jury to understand the chronology a little bit, put it in perspective.
Okay, what do you want me to do with this?
Well, I would fashion an instruction to the jury which tracks the language of this request for compulsory notice. Basically would say the jury is instructed that the public defender's office was appointed at March 7th at approximately 1:30 p.m. That additional appearances could not act on the defendant's behalf before that time, and that in order to obtain a blood sample from Mr. Bradley, the court order was necessary. The defense attorneys would have to have documented and did get a court order to obtain that blood sample.
Okay, and when are you requesting that jury instruction? At the time that I would normally do jury instructions?
That would be appropriate, sure.
Is it response from the state? And I don't know if you've had an opportunity to review this. I just saw it sitting on my desk.
I don't know that it's a jury instruction. I think that it's something the court would advise the jury that it has taken notice of as part of their evidence of it sometime during their case in chief.
But I think what the court's looking for is language we can both agree on, and whether it's in the form of instruction or the court says I'm taking notice of this, I don't care. As long as we agree on the language, and I just propose, I haven't read it up right now.
I mean, I could say that the court takes, for purposes of the record, and I could say to the jury, for purposes of the record, the court takes judicial notice that the Office of the Public Defender was appointed, and just read these.
Sure.
And I could do that this morning.
For purposes of the colloquy.
I could just say that the court takes judicial notice of.
And then read.
And then read 1 and 2. And then we'll wait on to see if I want to add the word knowingly. Was there any other matters we need to address this morning?
Well,
Judge, we had made a request last week to have our expert witness, Dr. Patricia Sapp, sit in for the testimony of the defense expert, Dr. Bowen. We are renewing that request that you have some case on the floor.
Okay. Yes, you may.
Total of 4 cases. Some of them are fairly voluminous, but the active part addressing the issue of sequestration is very small. Judge, in the first case, Burns v. State, cited 6097, page 600, it's Florida 1992 opinion. The appropriate or pertinent parts are head notes 13 and 14, which and the discussion on page 6 regarding those particular head notes. It essentially boils down to the fact that allowing an exception to the witness sequestration rule, particularly for experts, is in the sound discretion of the court. The next case chronologically would be the Hernandez v. State case, like this is their one in the stack. 4 Southern 3642, it's a Florida Supreme Court opinion from 2009. And the pertinent portions there are head notes 23 and 24. The discussions on page 16 and 17 of the opinion. There, the state experts sat expert and lay testimony that was presented. This was during the penalty phase, and the court found no problem with that. They did note that there had been a change in the statute about the witness sequestration rule, which allows certain exceptions to the witness sequestration. One of case of Hilton versus State Aid, cited at 117 Southern 3742 of the Florida Supreme Court opinion from 2013. There, a medical examiner was allowed to sit through the testimony of the defense experts, in part because the state was late in filing their notice of intent to seek the death penalty, and because they had been late in filing the notice, they were not allowed to examine the defendant. So there it was necessary for the medical examiner to sit through the testimony of the defense expert, and the court found no problem with that, and it did not lead to the change in the statute. And finally, there is the Blanco versus Neal case. It's a 2010 Westlaw decision 3027798. There they don't have head notes. It was an opinion by the U.S. District Court from the Southern District of Florida. And it was an ineffective assistance of counsel claim on the habeas corpus petition. It was claim number 2, which is at pages 8 and 9 of the opinion. There, the state expert was allowed to listen to the defense expert testimony. That was challenged both on appeal in the state court on 3.850, which the state court denied, and then published in the federal court. And once again, the federal court denied it, noting that it is not uncommon for experts to be allowed to listen to the other experts' testimony, particularly in a situation where the experts are essentially if they're not fact witnesses, that they're not going to get different facts, that they're all basically utilizing the same facts to form their expert opinions, and although their opinion may differ, they're not being influenced by any factual testimony that's different. Here we're not asking for Dr. Zapp to sit through the lay testimony of anybody. She would only be listening to the expert witness, Dr. Olander, who did have an opportunity to directly examine the defendant. In our situation, while we have obtained a court order that allows us to conduct an examination by Dr. Zapp of the defendant, the defense has objected to that until after the guilt phase is completed and before the penalty phase is completed. Our expert has not had an opportunity to examine the defendant directly, and he advises us that being able to listen to the defense expert testimony about her examination of the defendant would help clarify things in her mind as to whether the defense expert would became the verdict in her testimony. So we are requesting that Dr. Zapp be allowed to sit in Dr. Olander's testimony.
Okay, response from the defense.
Your Honor, Dr. Olander and Dr. Colloquy as colloquial independent-based witnesses, and here, I don't have a paper trail for this. It does present a little problem for my discussions with Mr. Master. I recall taking the position that since we are offering those two experts strictly on the issue of Miranda, that the state could have their expert evaluate Mr. Bradley on the issue of Miranda, but not as to what happened at the time of the shooting until we get to the penalty phase of the situation that was reversed. So that has been my position. I have not made him unavailable for an evaluation for that limited purpose. So the expert has had access for the purpose of evaluating the defendant in the context of what we're operating is mental health testimony for in this phase of the trial, which is strictly as to voluntary statement. And I would point out that in the cases cited by the state, Hilton and Burns, the state expert, the state's witnesses were exempted from the rule, and in light of the fact that the defendant was presented from examining the defendant, that is not. I don't claim that Mr. McMaster is misrepresenting anything, but here it would be best if we had a paper trail of emails which embody our discussions. But that's my recollection of it, and that's been my position, because that would be appropriate for me to make him available for that limited purpose in light of the use of word making of the defendant. So Hilton is distinguishable. Burns is distinguishable because I submit the state has not been presented, record has not been presented, and having their expert representative evaluate the defendant for that limited purpose. Hernandez, neither of those are elected. They don't. They just say the state, without saying what the essential showing was, they were found that the state met the burden, but they didn't go into the details on what it is the state had to show. So our position is the state has had access, and so and they also have had the report and all the information relied upon by Dr. Olander. So it is not essential for the state to have. It's not essential for the presentation of her testimony for her to sit in during the testimony of Dr. Olander. And also, we are disadvantaged in that although I had a chance to take the deposition, elected not to, but that was at one time before she had sat in and listened to the testimony of Dr. Olander and formed her new opinion, which should not be reflected in her report. So, procedurally, we're at a disadvantage. I object to the doctor sitting in. She's had ample opportunity to prepare, and the state has not made a showing that her being present in court during the testimony of Dr. Olander is essential for their presentation of their case. And as to the federal case, the court should not follow that to the extent that it generally relied on this. It would not follow the Florida state law.
Okay, I'm going to allow the state's witness to sit in during the testimony this morning. Can we talk about scheduling? I know the defense has the witness for this morning at 9. Is there any other witnesses other than that for the defense?
No. Well, no. We haven't gotten to the decision of the point of addressing whether Mr. Bradley will testify. Other than that, there are additional witnesses after Dr. Olander that participates.
Okay, can we get to the point where we get to the decision of Mr. Bradley testifying or not? Or can we do that this morning? Or okay.
Your Honor, give me a moment.
Okay. I think your microphone's been turned off. I haven't received any notice that they can't hear you when you've been speaking up.
An oversight on my part is I didn't line up a court reporter, and it would be nice if we had one, but if I am not on mic, then I should be, make sure that that record's so that we...
You mean not...
I'm
they're
asking to make sure the microphone is firm to be on at this point.
Don't you want a minute to confer with him in private?
I do.
Okay.
What I mean is after we...
Okay. I haven't received any notice that they haven't been able to hear you during your argument, so I assume either that mic or that mic's picking you up. That's what I'm assuming. Otherwise, they would have sent me something that said they can't hear you. And can someone just touch that mic to make sure it's off? Yeah, it's definitely off. Okay. All right, I'll give you a moment to confer with Mr. Bradley. Okay, can we go ahead and turn on the mic at the defense table? Okay, they're telling me they could hear you. They could hear you. Okay, can we go ahead and turn on the mic at the defense table? I think I could turn that on. Can you see if it's on now? Okay, I could hear it. It did.
You did hear that?
Yeah, I heard that.
Okay.
Okay, my mic's real sensitive. I have one right here, and it's super sensitive, and I heard you do that.
Okay.
I couldn't hear that before. Okay, Mr. Bradley, sir, I'm going to address you directly and ask you some questions. Mr. Moore has represented to the court that it is your intention not to testify. Do you understand that you have a constitutional right to testify in this case if you choose to do so?
Yes, ma'am.
And do you understand that you also have a constitutional right to make the decision not to testify if you choose to?
Yes, ma'am.
And have you had enough time to discuss this decision with your attorney?
Yes, ma'am.
Okay, do you need any additional time to discuss the decision whether you are to testify with your attorney?
No, ma'am.
Okay, and is it your decision? And it's my understanding, before I do that, it's my understanding that you're currently taking medication, is that correct?
Yes, ma'am.
And have you taken your medication today?
No, ma'am.
Okay, when do you normally take the medication?
At night?
Okay. And is the medication, does it affect your ability to think and make decisions?
No, ma'am.
Okay. Are you thinking clearly today with regard to this decision?
Yes, ma'am.
And do you understand what is happening today?
Yes, ma'am.
And has your lawyer or your attorneys in any way pressured you to make the decision not to testify?
No, ma'am.
And is it your decision, and solely your decision, not to testify in this case?
Yes, ma'am.
And is that decision your own decision?
Yes, ma'am.
Mr. Bradley, are you satisfied with the representation of your attorneys?
Yes, ma'am.
Okay. Is there anything you want your attorneys to do differently in your case?
No, ma'am.
All right, then thank you, sir. And the court does find that they had a colloquy with the defendant with regard to his right to testify. Okay, I do have some case law here with regard to it's a case Garcia versus the state, 125 Southern 3rd, found at 260. It's a March 6, 2013 case. And it was a recent case where the court gave an instruction with regard to freely, knowingly, and voluntary. And it says, it just talks about that the statements need to be freely, knowingly, and voluntary. I don't know if you want to look up that case. It says, in fact, the trial court, this is found on page 3, in fact, the trial court subsequently instructed the jury that it must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. And this is a 4th DCA case. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. So based on that, I will grant the defense's request and add the word knowingly. They talk about freely, knowingly, and voluntarily. So do you want me to add it after freely?
That's fine.
So we have one witness this morning, and then the state's going to rest. And does the defense is going to rest. Does the state have any witnesses lined up for this afternoon? Or for after that?
Yes, we do, Judge. We have 2 experts. One is currently present. The other should be arriving shortly.
Okay, so the state, I thought we talked about tomorrow morning, but maybe that was in reference to the other witness if we proceed to the next phase.
Right. For the penalty phase, our witness will be unavailable on Monday the 7th, I think it is.
Yes.
Okay.
Should be ready to go on Tuesday the 8th.
Okay, so the state would be ready to proceed after.
Yes.
Okay, any other matters that we need to address this morning? It is my intention to bring the jury in to talk to them about what I normally talk to them about with regard to recessing, give the state's instruction, give the judicial notice instruction, and then proceed with evidence.
Sometime today might be appropriate to start talking about sequestration or possible sequestration.
If you want to make that request, you can make that request.
I don't know that we make a final decision on that. Not at this point.
Okay, I don't intend to address that unless a request is made, then obviously I'll address it, but I don't intend to address that unless a request is made.
Well, better deal with it, I would suggest, because if it goes to the jury tomorrow and they run into the evening hour, then the issue is going to come up, and it'd be best for them to not be brought blindsided with that when they go out. The earlier they know, the sooner we can get some response from them as to whether it's going to create a problem with them that would prevent them from sitting on the jury. So I would suggest that it be brought up when the court brings them in this morning, that there is a possibility of that tomorrow.
Okay, when you say possibility, I want to hear the issue when it's either going to happen or it's not going to happen. I don't want to talk to the jury in reference to possibility.
If they go into the evening hours, and we're going to request it. So I mean, that's as definite as anybody can be in predicting. We are requesting it.
Okay. Okay, response from the state.
Judge, I think it's quite clear that unless both parties agree to waive, which we do, but apparently they're not, that they are to be sequestered during deliberations. So it may be best to advise them that we anticipate they will be deliberating tomorrow, and that if they break for the evening without a verdict, that they'll be sequestered until they reach a verdict.
Okay.
So, obviously, if they reach a verdict tomorrow afternoon, tomorrow evening, that is not an issue, but maybe safer to advise them there's a possibility.
Let's do this, Judge. I think the better approach is that I can agree not to sequester the jury and that we don't need to go through this, on reflection.
Okay.
I really haven't given it a lot of thought until just now, but as I reflect on it and talk to co-counsel here, I think it's probably best if we not insist on sequestration, in fact, waive it. So that would be my request at this time. So we don't need to go into it.
Okay, so the defense agrees that it can be waived. Does the state agree that it can be waived?
Yes.
Okay. Okay, thank you. Okay, are we bringing the jury? Are they up? Okay, thank you.
Is our mic still on, or? No?
It's off.
Bring the jury up, it's never with this now.
You can do that? Okay, any other matters before we bring the jury into the courtroom? State's ready to proceed?
Yes.
Defense is ready to proceed?
Right.
Okay, well then we'll bring the jury in.
All rise, jury present.
Please be seated. Good morning, ladies and gentlemen of the jury. Has anyone read or been exposed to reading newspaper headlines and/or articles relating to this trial or its participants? Has anyone seen or heard television, radio, or internet comments about this trial? Have you read any news headlines or articles relating to this trial or its participants? Has anyone conducted or been exposed to any research regarding any matters concerning this case? And have you discussed this case among yourselves or with anyone else or allowed anyone to discuss it in your presence? Okay, there's a few things I need to read to you at this time. Evidence of any abnormal mental condition is not a defense to any crime. Evidence of a defendant's abnormal mental condition may not be taken into consideration to show that he lacked the specific intent to commit any crime. Such evidence is to be considered by you only for the purposes of determining the defendant's interview, only for the purposes of determining whether the defendant's interview was freely, knowingly, and voluntarily made. Now, at this time, the court is going to take judicial notice that, one, the Office of the Public Defender was appointed by the court to represent the defendant in this matter on March 7, 2012 at approximately 1:30 p.m. and would not be statutorily authorized to take action in the case prior to that point. Number two, an order by the court would be necessary to obtain a blood sample from a defendant. Okay, who would be the next witness on behalf of the defense?
We call Dr. Jacqueline Olander. Could I have a moment before we proceed?
Yes, you may. Ma'am, if you'll come forward, step up before the clerk to be sworn.
You can raise your right hand. Do you solemnly swear or affirm the testimony you shall give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
And if you'll be seated in the witness chair. And once seated, that chair does roll around. If you'll scoot that chair forward, do adjust that microphone to fit you. And do talk into that microphone. It helps everyone hear your testimony, and it also aids in recording your testimony.
Yes, Your Honor.
Okay, Mr. Moore.
Thank you, Your Honor. Morning, Dr. Olander.
Good morning.
Would you identify yourself, please?
My name is Jacqueline, and that's spelled Jacquuelyn, and my last name is Olander, Olander.
All right. What is your profession?
I am a licensed psychologist in the state of Florida, and I also have a specialty in neuropsychology.
How does the specialty of neuropsychology differ from the specialty of psychology?
In many ways, it's quite different. To practice as a neuropsychologist, you have to complete a doctoral training program in the field of psychology, which is the study of human behavior. Then you switch over to the field of medicine and obtain your training in a 2-year residency in a hospital setting and learn about the brain, neuroanatomy. You go to various brain cutting, so you actually see what the various parts look like. You go through a regimented training program at a hospital setting. You're under the Department of Neurology. The field of neuropsychology actually began many years ago, before there were CT scans and MRIs. What we found in our study of the human brain was that different parts of the brain controls different areas of functioning. So back in the 50s, before there were MRIs, the doctor could clearly identify that this person has a brain tumor, but doesn't know where it's located. In order to do an operation, they would turn to us as neuropsychologists because we had the ability, through doing paper and pencil tests, to find out which areas were preserved and which areas were damaged. Thank you. So based upon our findings, the doctors would know where to go in to operate and find the damaged area of the brain. Now, as time passed and we have CT scans, PET scans, and other neurocognitive imaging, what they have found that our field is best on defining the relationship and understanding the relationship between brain functioning and human behavior. So if a neurologist suspects somebody might be coming down with dementia, that would not show up on a CT scan or an MRI in the early stages. Instead, they send them to us to start doing these testing, because research states that neuropsychological results are the best ways to identify the early stages of dementia. Another area that we're used for is when there is a brain injury. Again, MRIs and CT scans and PET scans can identify areas of abnormality, but they don't translate that abnormality into specific human behaviors. So as a neuropsychologist, our special niche is looking at the relationship between brain functioning and, human functioning.
And as I understand it, one of the ways you do that is through neuropsychological testing.
Absolutely. It is a very critical discipline that requires that rigid training. And for a person to administer neuropsychological testing, particularly for forensic or legalistic matters, it is critical that they have that 2-year residency on top of everything else to get that specific training, because you have to be trained to utilize the scientific method in completing neuropsychological evaluations.
You belong to the National Association of Neuropsychologists.
Yes, I do. That is one of the governing bodies for the field of neuropsychologists. psychology. It works very closely with the American Psychological Association.
It would be that's the NAN, National Association of Neuropsychology. Are there guidelines promulgated by the NAN that establish minimum criteria that a neuropsychologist would need to meet in order to be a practicing neuropsychologist?
Yes, there's a number of what is called position papers developed by the National Academy of Neuropsychology that establishes the training and the background necessary in order to administer tests and interpret tests and utilize them, particularly in a forensic field. Now, again, as I previously testified, the NAN, which is the National Academy of Neuropsychology, works very closely with the American Psychological Association, APA, in establishing the practice of ethical behavior in our field as a licensed psychologist. Talks about the boundaries of competence, in other words, what we are qualified to do, and particularly as it pertains to requests from third parties.
Have you met the criteria established by the NAN to be a practicing neuropsychologist?
Yes, I have.
Now, as I understood, backing up a little bit, that there are specific tests which you can give and have given, which are suggestive of brain damage or brain injury.
Yes, on many occasions.
Not diagnostic of, but would perhaps suggest further, more specific testing, like what?
Well, I think what you're talking about is are there screening instruments? So if somebody comes in, instead of give a whole battery of tests, which takes hours and hours, you can give various instruments initially to determine whether or not it suggests the presence of brain injury or brain dysfunction.
Well, so suppose you have results in a test or those types of tests which indicate the possibility of brain damage or brain deficit. What type of more confirmatory, more definite diagnostic tools might you recommend?
If I have results based upon the individual's presentation which suggests that there's a cognitive damage or brain damage presence, and then my testing is consistent with that, but sometimes people who have brain injury can have difficulties recalling dates or very specific details because when the brain is injured, it does not form memories very well, or if at all. I remember many years ago when that accident with Princess Di, and everybody was waiting for, I believe it was the one gentleman who survived, to wake up so he could tell what happened. I told my colleagues that if he was able to do so, I would have serious concerns because when somebody has a brain injury, we have what's called post-traumatic amnesia. So their ability to remember what happened is greatly impaired.
What I'm getting at is if you have such a finding, if you have such a presentation and test result which suggests there may be a brain injury, would you recommend, for example, an MRI or a PET scan?
Yes, absolutely. And I pretty long-winded, I apologize. But yes, that would be the next stage I would go to see if an MRI or PET scan could clearly document the presence of brain abnormality.
Dr. Olander, what do you do? What is if you have a practice, and so what does it consist of?
I am in private practice in Winter Park, Florida, and initially when I started over 15 years ago, I had approximately 50% of my time was therapy, and the other 50% was evaluations. Now in the last 5 years, I do more evaluations than I do therapy. And my evaluations cover a wide variety. Criminal situations such as this. I also evaluate people for disability. I'm an old school teacher, guidance counselor, school psychologist, program administrator. So I evaluate students for the potential of learning disabilities and to obtain accommodations when they enter college for extended time on exams and other forms of accommodations. So I do a wide variety. I have a very eclectic background.
What sort of professional associations you belong to, certifications, licensures, you haven't already mentioned?
Yes, I'm licensed in the state of Florida as a psychologist. That's a protected term. I'm also certified in the state of Washington, where I obtained my master's. I have a certification as a school psychologist, a guidance counselor, and an elementary and secondary teacher. I belong to the American Psychological Association, the National Academy of Neuropsychologists, and also another neuropsych body called the International Neuropsychological Society, the INS.
Have you testified in court before as a neuropsychologist?
I've testified on multiple occasions, approximately 150 times, in either, vast majority in court, but also in depositions.
Okay, and were you contacted by my office and asked to do an evaluation with respect to Mr. Brent?
Yes, I was.
As it relates to the Miranda issue and voluntariness of this statement that he gave to the police, what were you asked to evaluate?
I was asked to evaluate Mr. Bradley in regards to his ability to knowingly, voluntarily, and intelligently waive his Miranda rights.
And give a statement?
And provide a statement, yes.
And what materials have you considered in that evaluation? What have you done with it? Well, let's just focus on the materials and also whether or not you have actually done a face-to-face interview with Mr. Brent.
There was a number of materials or records I reviewed. I reviewed his school records from Cobb, Georgia, and well as in Brevard County. I reviewed his records from the Department of Corrections. I reviewed the police reports related to this, his current legal situation. In those police reports were narrative statements, an extensive, over 100 pages of the chronology of the events that occurred. I reviewed his, medical records from his incarceration at Seminole County Jail. I reviewed the records, and I probably will mispronounce the name. Is it Rustov Hospital?
Exactly, right.
Okay. I also reviewed the report from Dr. Scully Danziger when I created this report. Let me see, I'm just checking my notes here. I believe those are the primary ones I reviewed.
Okay, did you consider reports from Dr. Joseph Wu or Dr. Mark Herbst?
Okay, those I obtained after this report was generated. But since the report was generated, I reviewed records from Dr. Wu, which was an MRI and a PET scan, PET, and then from a Dr. Herbst, who did a blind study of the MRI, and an updated report from Dr. Scully Danziger, and video of the actual shooting. I reviewed that since then.
Did you rely on, is that a comprehensive list? Do you think you included everything?
As best I can recall.
And you actually interviewed Mr. Brent?
Yes, I saw him on 2 occasions.
And were you assisted in your interview with Mr. Brent?
On the first one, I had a resident with me, Dr. Spicer, who came to fulfill part of her postdoctoral experience in order to obtain the training in neuropsychology. She was there, assisted me on the first one, and I did the second one all by myself.
How much time have you spent talking to Mr. Bradley, including the testing? Well, break it down into this. 2 meetings with him, part of that was an interview.
Correct.
A portion of your meeting with him, and other parts were devoted to testing, giving actual tests. So can you break that down?
I spent approximately 6 hours with Mr. Bradley. Probably half of it was obtaining information, what we call the interview stage, and the second half was for testing.
Did you, in reviewing his records at the Seminole, the full Correctional Institute, did you note whether he was on psychotropic medication?
Yes. Not initially, but definitely by the time I saw him at the second evaluation
Do
date.
you recall what those were?
Primarily Risperidone, which is an antipsychotic medication.
And Andoxafen?
Yes, it's another one that's used to assist people who are having difficulties controlling their psychosis and require additional medication.
With you work in the criminal justice system, you work in the courts frequently, and you have done evaluations in criminal cases before, have you not?
Yes, on multiple occasions, both hired by or requested by the defense, but also almost as frequently by the state in a court order.
Those would be state attorneys, prosecuting offices.
Yes, sir.
As far as the ability of an inmate in a jail, such as Mr. Bradley was when you saw him, to obtain those psychotropic medications, that would require a prescription written by a medical doctor, a psychiatrist.
Correct. Correct, although regular doctors can prescribe some of the medications, although for more complicated, they generally refer to a psychiatrist. And also a physician assistant can prescribe medication, but again, usually it's at the request of a psychiatrist. They're the ones who direct and control the care of a patient.
Did you tell Mr. Bradley what the reason for your evaluation was?
Yes.
And why you were there to evaluate him?
Yes, and also I explain the non-confidentiality of this evaluation, because people, when they see a doctor, particularly a psychologist, assume confidentiality exists, and in most cases it does, but not this one.
What did you tell Mr. Bradley was the reason that you were evaluating him?
For the first time I saw him in March, I was evaluating him at the request of his attorney to assist with his legal case. And at the second time I went to see him in November, I explained to him the purpose was to assess his understanding, ability to understand knowingly and voluntarily provide a statement to the police.
Did it help you to interview Mr. Bradley twice?
Of course. I often, when I do neuropsychological evaluations, break it up into 2 days. First of all, the completion of a neuropsychological evaluation takes many hours. I get tired, and I know that if I'm tired, and I'm not doing most of the work, I know that the individual I'm testing is probably even more tired than I am. So I don't like to have fatigue become what I call an extraneous variable, a factor that could influence the outcome. So I prefer to break it down into 2 sessions.
Did you notice a change in his mental status between the first interview and the second interview?
Yes, I did. During the first interview when I saw him, he reported experiencing auditory hallucinations, and his presentation was consistent with that. He appeared to be at times internally distracted. That's a way of saying that he was responding to internal stimuli, whereas at the second interview, I did not observe that.
And was there, between the first and the second interview, was there an indication that he began the medication that you just described between the first and the second interview?
Yes, and he reported at the time I was evaluating that he wasn't hearing voices.
You believe you could give a thorough, competent evaluation in a situation like a case like this, definitely case, without a face-to-face interview with a friend?
It would be very difficult to provide an opinion in this situation, given the severity of this legal case, without having a face-to-face interview. I know that people review records, and I've been done that, and sometimes I've been asked to do that. But my confidence in my opinion is significantly lower compared to my confidence in providing an opinion when I had the opportunity to be face-to-face with the individual.
Now, of course, there's always a potential in a case, criminal case in particular, definitely case for malingering or deception. Now, would you Explain to the jury what malingering means and how you address that in your testing.
Okay. In the field of neuropsychology, it is critical for us to have confidence that when I'm administering these tests, that people are, first of all, reporting what they truly believe or perceive, because there's a difference between perception and reality. And so it's critical for me to have confidence that they're providing information they truly believe. And secondly, that they're actually trying to complete these tasks with positive motivation and effort. We call that faking bad or malingering, when somebody purposely tries to do poorly on tests in order to manipulate the outcome of the evaluation. That's known as malingering. As neuropsychologists, we are at the very top in understanding and assessing malingering because it is most critical to our field. Again, both in malingering cognitive data, that's the completion of these tests, as well as self-reported data, what they tell us about, the historical background, their perceptions and understanding. So when I complete a test, particularly for forensic purposes, I make sure that I administer sufficient measures of effort and motivation so that I would have confidence in my findings. Without it, this is useless.
So on the issue of malingering or deception, does it help also to judge the person's body language, attentiveness to the task, whether the person is giving full effort, in your opinion? Is that part of the assessment as to malingering?
Yes, it's important to ensure that behavioral observations are consistent with the test results.
Describe one of the tests at the Paul House, if I'm pronouncing that right.
Yes, you are.
Deception test. Would you describe that to the jury and what the results were?
I find the Paul House deception test it's called the scales, PDS, I found that to be a particularly relevant test to administer, particularly in regards to areas of competence. The Paul House deception scale is a measure of dissimulation, which is a fancy way of saying lying. It has also measures of positive motivation. In other words, is a person who's completing this trying to positively manipulate the outcome. So in other words, by lying or exaggeration. This is related to self-reported data.
Was the Advanced Clinical Solutions another test?
Yes, it is. It has a number of subtests that assesses the cognitive aspect of testing, whether or not a person was putting forth, positive motivation and effort on paper, what we call paper and pencil tests.
And was that administered to Mr. Bradley?
Yes, the 3 subtests were.
And what were the results of those 2 tests?
The results of these tests did not give any indication that he was purposely lying or dissimulating or trying to manipulate the outcome of the self-reported data. And there was no indication that he was trying to fake bad on the tests.
You also gave some standardized tests related to the Miranda issue, did you not?
Yes, I did. And one of them actually had a test of malingering, and he passed that as well.
Okay, with that, which was that the SAMA?
Yes, it was one of the subtests of the standardized administration of Miranda abilities, the SAMA.
Let's talk about the Miranda testing at this point, and then we'll get into some of the other tests we did. The standardized assessment of Miranda abilities, what is that? Describe that to the jury, and then what scores you got from Mr. Bradley, that test.
It's a series of subtests that examines a person's understanding of the vocabulary, in other words, the words included in the Miranda rights, his comprehension on understanding of the Miranda rights. It also measures a person's misperceptions or distortions in the understanding of the Miranda rights, and it also measures a person's level of acquiescence. In other words, how likely is that person would acquiesce to a strong authority figure in their responses, as well as the specific details of the events surrounding the waiving of the Miranda rights.
And he scored at the first percentile on one component of that test, did he not?
Yes, he scored at the, well, it depends upon how we frame it. He scored at the 99th percentile in regards to his tendency to acquiesce.
Now, when we're talking about percentile, just describe to the jury what that means, what information you get from that analysis of, if you put them, rank them according to a percentile score.
And the way I describe this to my patients, and all the way from here up to here, if I have 100 people in my office, only if somebody scored at the 99th percentile for something good like an IQ test, I would tell this individual that if I asked everybody to leave this room except for those who did as well as you did, how many people would be left? And if somebody scored at the 99th percentile, there'd only be one other person left in the room. Kids can get this. That's how well they did. But if this is a test that measures weaknesses, it would have the opposite. In other words, of the 100, 99 people would do better than you would have done on this test.
And so what was the component as to which he did a first percentile score?
Out of 100 people, he would be almost at the very bottom. There'd only be one person who did worse than he did.
So overall, with respect to the standardized assessment of Miranda abilities, what was the overall performance on that test?
He has extremely high, I know we're switching back and forth. His tendency to acquiesce is extremely high. He would be somebody who would be very easily manipulated. He's a passive dependent individual and be very easily manipulated by others.
Okay, on the other tests, did you derive any other further information from the sampling we just discussed?
Well, part of the problem is that Mr. Bradley reported having no memory of the time in which he reportedly freely, voluntarily, knowingly waived his Miranda rights. So that aspect of the test I could not administer because he has absolutely no memory. However, that not having that one piece in no way influenced the other aspects of the subtest that were administered.
In your experience and training, have you found that people who consume drugs around the time of an event, like Xanax, benzodiazepines, for example, that affects their memory?
Oh, absolutely.
In what way?
Let's talk about marijuana. I've taught every grade level, and when I was teaching at college at Valencia, when we got to the section about drugs, as a teacher, as a professor, marijuana clearly interferes with the ability to learn and store new memories. It is not the innocuous drug, particularly for younger brains, teenagers and 20s. It's not the innocent drug when it comes to memory and learning because it clearly influences the forming of new memories, without a doubt. That's been very well documented. It also has been found to lower IQs in research.
How about the ingestion of large quantities of Xanax? Is there any literature or through your training, experience, or exposure to the literature that suggests that would cause an event to be erased from someone's memory?
It doesn't cause an event to be erased. Those memories were never there.
So if Mr. Bradley consumed a large quantity of drugs, including Xanax, preceding the waiver of Miranda, the giving of the statement, would that be consistent with the effects of the Xanax on Mr. Bradley that he couldn't remember?
Yes. Again, it has to do with the total amount of drugs ingested over a period of time.
Would you describe the Grisso testing that you did?
Okay. That is an older instrument that was published back in the late 90s, whereas the SAMA was published in I think it was 2012. That is a simpler measure of Miranda rights. What it does is it focuses more on knowledge of vocabulary, knowledge of comprehension. It doesn't really assess the person's ability to apply that information to their specific legal circumstances. It's more a measure of simple rote memory. In the classroom, we used to call these tests, are students able to regurgitate the data rather than apply it specifically? But that was a good instrument for the time.
What was Mr. Bradley's performance on that test? What did you learn from that test, and how did that apply to your opinion?
Okay, on that test, he demonstrated a fairly normal ability in most areas, except his ability to apply that knowledge. That was significantly lower. So in other words, he could regurgitate the information, but he had a difficult time actually applying that information.
Now, was that after you gave the Paul House test, which indicated that he was not malingering?
Oh, yes, yes. I do the malingering test at the beginning.
Did you consider other test results? Did you administer and consider other test results?
Well, as I'm doing these evaluations, I appreciate the findings of other test results that I administered earlier.
Right, one of those was the Dulles Kaplan, would that be correct?
Yes.
And what was the nature of that test, and what was the purpose of it?
The Dulles Kaplan is a measure of frontal lobe or executive skills functioning. Now, in neuropsychological testing, particularly when there's concerns about the possibility of brain damage, this is a critical measure. The frontal lobe or the prefrontal lobe of the brain is what distinguishes us from other animals that exist on this planet. Our frontal lobe or prefrontal lobe houses those unique quality of human functioning and human behavior. It incorporates our higher level thinking and reasoning, particularly abstract reasoning, but more than anything else, it houses our self-control and self-regulation, self-knowledge, and self-awareness. If I'm comparing the brain to a computer, another way of understanding the executive system is you can have a fine penny processor, like ones that exist today, and I'm not at all have much technical knowledge. But what the prefrontal lobe is, it's our operating system. So in other words, if you have I know they don't call them this anymore, but like a dual core processor, and you're trying to run it on, one of the first Windows, Windows 98, you may have some abilities there, but your ability to tap in and effectively utilize it is prevented because your operating system cannot handle it.
Is the orbitofrontal cortex part of that frontal lobe?
Oh, yes, it is. In fact, the orbital frontal cortex holds the pathway between the frontal lobe or the prefrontal lobe of the brain, which regulates and helps us control and self-control, and the emotional component of the brain. It's the pathway. So if there's a disconnection there, there's an organic disconnection between our ability to control, manage, and inhibit our emotions.
Are there various components of that test, correct?
Yes, there are.
And were there performances of Mr. Bradley's on various components which were sufficiently low to be suggestive of further testing on the issue of whether he may have brain damage?
Oh, absolutely. In fact, on a couple of the scores, it was below the first percentile. It was extremely low.
Then another test was the West Shore Adult Intelligence Scale 4. That
Yes, that's the most recent adult IQ test, which is considered the gold standard in regards to testing people's intellectual functioning.
And were there components of that test which also, if scored sufficiently low, would suggest brain damage?
Right. A couple of the areas you'd look for would be his processing speed, as well as what is called working memory, because that's part of the executive system. And also the similarities test, which has to do with abstract reasoning, which requires that prefrontal lobe.
And he scored in the second percentile for processing speed.
I'm just reviewing.
Yes, ma'am. Refresh your memory if you need to.
Okay.
If you would point out the components of which he scored were significantly low.
His, on the measure of processing speed, there were two tests that are combined to produce an index score. He performed at the second percentile. And
Any other components where he scored low on the WACE?
his attention executive component was at the fourth percentile.
Verbal comprehension?
That was fifth percentile. Again, those all fall within the impaired range.
Full scale IQ under the Wechsler test?
It was at the second percentile.
Now, you also considered his Department of Correction, his prison records, did you not?
Yes, I did.
And in one of those, it was indicated that back in about 2007, correct me if I'm wrong, 2008 perhaps, an IQ of 96 on what's called the beta test.
Yes, I think it was administered in 2010.
Now, how would you, which is the preferred test, the WACE, the Wechsler test, or the beta test? What's the difference between the two?
It's significantly different. The beta test actually first was created in 1917 by, I think it was Robert Yerkes, a psychologist for the military. This was, as you can recall, around World War I when the draft was implemented and there were a number of individuals coming into the military. Back in those days, they were highly intelligent people who were not really literate because that was society. So the military had to come up with a quick way of finding out people's intellectual functioning in order to place them in the best place where they would be useful for the military. So they came up with the alpha test. These were tests for people who were literate, and they were large group tests. And then the beta tests were people who were not literate, but and these were called nonverbal. A
Nonverbal, did you say?
Right, nonverbal. In other words, you would not need to read or read very well in order to complete this test. An example of a problem that is considered nonverbal would be you would have a puzzle with three pieces kind of in a box and one missing, and then you'd have a visual picture. Maybe they could be all balls, and this is a very simplistic one. Then you would have responses to choose. You could have a square, a triangle, a rectangle, and a ball, and you'd have to identify what was the missing piece. So that would be a nonverbal way of assessing a person's intellectual functioning without needing language or the ability to read. Now, after World War I, the military no longer used those instruments. Whereas I think it was in the 30s that another group of doctors got together and said, let's take this beta and try to develop it and use it for civilian purposes. So the beta 3 came to exist back in the 30s, and it is a group test, but it's mainly based upon nonverbal subtest. It's a quick screen. It's not time limited. Excuse me. And it can be done in a large setting like this. So it does not assess executive skills, which is critical in this situation. It doesn't assess language, and it really doesn't assess processing speed, which is, again, critical in this situation. It only really assesses the nonverbal aspects of functioning.
How would you explain the difference in over a 5-year period, 2008, under the beta test, President gave, which is a short, fairly quick test, a score of 96, and the results you got on the Wechsler test some 5 years later.
Well, what's interesting is the closest test that I administer would be part of the IQ test called matrix reasoning. It is a nonverbal test that is not timed. That was the highest score that Mr. Bradley obtained. It was at the 25th percentile, which is considered below average. So that isn't significantly different than the beta test. But again, that's one isolated part of the brain. It doesn't take into account the comprehensive measure of the brain. It is not timed, and it doesn't include, again, the executive skills, the processing speed, which a full-blown IQ test would utilize. I'll give you another way of looking at the beta test. As a school psychologist, we are at times asked to do IQ measures when I was in the school system to determine a child's placement into a gifted program or whether or not he had a learning disability. The beta test is not accepted by the state of Florida as a means to evaluate a person's cognitive abilities. It's not accepted as a test to measure whether or not a person previously would be called mentally retarded, now is called intellectually disabled. So it's not qualified to provide opinion for those purposes.
Of course, an accurate picture of IQ would be important for you in this assessment, would it not?
Oh, of course.
Because one of the aspects is whether he's knowing and intelligent waiver, and the statement was a knowing and intelligently given.
Yes.
Voluntarily given.
Correct.
Now, would drug use, drug abuse, chronic drug use, drug abuse, and brain damage, would those possibly explain the difference in the IQ performance scores between the beta test and the Wechsler?
Yes, and of course, again, looking at the results of the neurocognitive imaging test, the MRI and the PET scores, that's in related to processing speed and executive skill functioning. That was not assessed in the same way as it was on the IQ test, and I don't think there's any measures of executive functioning.
Did you take into, and did you recommend, as a result of the testing you've been describing, that Mr. Bradley had neuroimaging testing done?
Yes, I did. I referred that to you, I think, the exact day after I saw him.
And did you consider those test results that came back from the tests that were given, the neuroimaging test, in your opinion?
Yes.
Okay, did you rely on those results?
Yes.
Okay, and what were the results made known to you, and how did they affect your opinion?
Are you talking about my test results or the neuroimaging?
Neuroimaging tests you were made aware of.
I had already provided an opinion before I got that based upon my own data and the records I reviewed, but having given the additional information, it completely supported my initial opinions.
You had some information, did you not, of head injury in Mr. Bradley?
Yes, he consistently reported to me that he had one very serious head injury and the other two that could have easily resulted in a head injury.
Was this the results from the PET scan and the MRI? What effect did they have on your consideration of whether he had actually experienced head injuries in the past?
It added additional corroborative data to support my opinions. It was very clean, very clear, very consistent.
And was your recommendation of the neuroimaging testing done to help corroborate or confirm what you suspected through your testing?
Yes, I sought additional information, and it was obtained, and it created more validity to my opinions.
Did you also you viewed the DVD of the interrogation?
Yes.
Now, there's a portion preceding when the interrogation actually begins.
Quite a long time.
Quite a long time, and during which Mr. Bradley is doing what?
Falling off the chair and sleeping.
And that's before the police walk into the room and begin to question him.
Yes.
And what period of time is that, do you recall?
I think the actual video began around 12:45
p.m.
And then it lasted for hours.
That's like 12:45 on March 6th.
Yes.
And could you tell whether Mr. Bradley is sleeping or passed out, and if so, what inform that opinion?
Well, he initially was put on a chair, but sometime later he fell off the chair. And you can hear snoring, you can hear mumbling, you can hear people coming in trying to arouse him with not being successful.
Is that what you observed?
Yes.
An officer come in to try to wake him up?
Yes.
And how successful was that effort?
He wasn't. He mumbled, and he wasn't able to get him more alert very successfully. And it wasn't until the actual time the two officers came in that you heard more than just mumbling or a few sentences or words.
Okay, and would perceptual distortions be something you would consider if you observed them, Mr. Bradley, in informing you to help you reach the opinion of whether his statement and waiver of Miranda were voluntary?
Yes, he reported a significant history of psychotic experiences. Also, he was very paranoid when I saw him on March the first time. He was actually, when he was explaining his beliefs, his distorted beliefs, he actually was concerned about my well-being and shared with me the importance of not taking an oath, because an oath, if I took an oath, it would make me vulnerable to being taken over by the dark side, so to speak.
What I'm asking is the perceptions of that Mr. Bradley expressed during the interview of being shot, fear of being shot.
Yes, it would be quite relevant because it would integrate his personal experience, his personal history with his psychosis.
And would that also influence your decision about whether he was knowingly, intelligently, voluntarily able to waive Miranda and give a statement?
Yes, all of the pieces would be important.
Were there other points where Mr. Bradley expressed that concern about being shot, which would lend to your opinion about, or influence your opinion about, whether he was experiencing perceptual distortions?
Yes, and both times I saw him in March and then later in November, he described a belief that he was going to have a very short life, that he had personally experienced 5 deaths within a very brief time, I think beginning at age 15 with the death of his grandmother, and then his cousins and close friends who had all been shot. One was accidentally blown up. And a belief system that he would experience the same outcome. Also, he described about a week before his legal circumstances occurred of having a hit placed on him, and that somebody was trying to kill him.
Well, specifically, I mean, you viewed the DVD of his statement.
Yes.
The focus here is trying to figure out if he's in touch with reality or not, perceptual distortions, as it relates to his ability to waive Miranda and give a voluntary statement. That's your focus?
Yes.
Okay, during the DVD, your viewing of the DVD of the actual shooting, was there any evidence there that would form your opinion about whether he was undergoing perceptual distortions?
I'm going to object this morning, Mr. Crouch.
Yes, you may. My screen's down. You're going to have to put us on bench conference. I have a screen up. You all need to fix my screen. Thank you. Go ahead.
Doctor, did you, in viewing all the information that you considered, that in giving, in reaching your opinion about the voluntariness of the statement and the waiver of print, did you also consider and rely on what you heard in the DVD of the actual shooting?
It helped corroborate and support my findings. When I complete an evaluation,
Did you rely?
Okay, so she's asking the next question.
Did you rely on that information?
yes,
Okay. And so, what was it that you heard that you relied on in that? What did you hear in the DVD that you relied on?
You know, object. That's the approach.
Okay. I need a bench conference, please. Go ahead.
Okay, Doctor, focusing on the DVD of the shooting. What did you hear? What statement did you hear or statements in that DVD which you relied on in forming your opinion about the voluntariness of the giving, Mr. Bradley, giving a statement to the police?
his statements were consistent with the presence of paranoia.
Well, what statements did you hear?
Okay, overruled.
The statements were questions asking the police officer
By whom?
by Mr. Bradley, are you going to shoot me? Why are you going to shoot me?
How many times did you hear that?
Multiple times.
Did you also consider the deposition testimony which you were provided by Andre Kirshner on that issue?
Yes, it was part of the materials I reviewed in formulating my
Did
decisions.
you rely upon that deposition of Andre Kirshner in reaching your opinion?
Yes, it was a piece.
Was there an aspect of a statement that Ms. Kirshner attributed to Mr. Bradley during the time leading up to the shooting?
She spoke about irrational behaviors.
A statement that he made.
Oh, the maid. Trying to think. I don't know if I can recall it verbatim, but it was related to about being shot for this.
And assume for purposes of this question about your opinion that when Andrea Kirshner testified, she also said Mr. Bradley asked just before the shooting if he was going to be shot. Assume that as well.
Yes.
How does that affect your opinion?
Again, it supports the opinion that this was a man who was suffering from paranoia, consistent with a psychotic experience.
Yes, you may. You need to go bench conference, please. Yes, sir.
Did you also consider Mr. Bradley's drug history
Yes.
in reaching? Now, we're focusing on Mr. Bradley's ability to give a voluntary knowing intelligence statement to police and waive Miranda. That's what we're focusing. In connection with that, did you reach an opinion about that? Did you rely upon his drug history?
I relied upon many aspects of his history, including his drug history.
Okay, as it relates to the drug history, as it relates to Bradley's ability to give a voluntary statement, did you see, did you collect evidence from him? Did he give you a history of drug abuse?
Yes.
Did it fit any profile, of whether it's drug addiction or drug abuse? Did it fit any profile?
It fit the profile of having a substance dependence disorder.
In fact, that was one of your conclusions, poly substance abuse disorder?
Yes.
And was that confirmed in any of the records that you reviewed?
Yes.
Did you see in your review of the Department of Corrections records and also the information that was collected at the Broward County Jail and the Polk County Correctional Institute, the Polk County, Seminole County Correctional Institute, as well as the 2008 records from Woodstock Hospital related to the automobile accident, which confirmed the history of drug abuse and drug dependence?
Yes, they were all consistent.
Well, what did you see? What did you read?
That
you relied on those, did you not?
Yes.
So what did you read that you relied on?
In the accident that occurred in 2008, the motor vehicle accident, he had ingested drugs were found in his tests. And he reported a significant history of dating back to, I believe, age 12, beginning with marijuana, and then following marijuana, ecstasy, a number of other drugs that he had used consistently, and even more so following his motor vehicle accident. His increased significantly, particularly after he was released from DOC up to the time of his arrest. He had ingested multiple drugs in multiple quantities.
Are there parts of the brain implicated that perhaps showed up in the MRI or the PET scan, which are involved in drug dependency or proneness to drug addiction?
Yes. In fact, the areas of the brain that were damaged have been found to be related to addiction issues. It's that pathway between self-control, in which we can override our instinctive urges, that was disconnected, and that has been associated with addiction and addiction problems.
What part of the brain are you talking about?
I'm talking about the pathway, in other words, the freeway system of the brain between the prefrontal lobe and the limbic lobe, which is related to issues of motivation, drive, and emotion. That was the area that's damaged.
When you say it was damaged, then how do you reach that conclusion?
That was consistent with the results of my neuropsych testing and also consistent with the MRI and the PET scans completed.
People who have mental health issues self-medicate?
Very frequently.
Now, in those same records that we just mentioned, the Department of Corrections records at the Broward County Jail, Seminole County Jail, Woodstock, was there a portion of those records in which information was entered as to whether Mr. Bradley ever had mental health issues?
He denied it at that time.
Okay. And so what would be an explanation for that if somebody has mental health issues in being interviewed at the jail, either jail or the Department of Corrections or Woodstock Hospital when he's in the emergency room being treated for an automobile accident? What would be reasons why that information would be in there if he, in fact, had some mental health issues?
Okay, bench conference. If you could go to bench conference, please. Go ahead, Ms. Rowe.
Okay, you have evaluated Mr. Bradley, and you have a profile of Mr. Bradley based upon a number of things. Your neuropsych testing, your face-to-face evaluations, everything you consider. And and among which you considered would be the records from I just referred to a moment ago, from the Brevard County Jail, the Seminole County Jail, the Department of Corrections, Woostoff Hospital. Why, if Mr. Bradley was experiencing mental health issues, would they not be reflected in those information sheets as that relates to Mr. Bradley?
I asked him that question, and his response was consistent with what I had hypothesized would be. As an old school teacher, I spent 16 years in the public school system. I was a guidance counselor.
Okay, I'll sustain the objection.
Okay.
You asked Mr. Bradley.
Yes, he said he was ashamed and embarrassed about it, and he didn't want people to think that he was crazy.
He has a high school education.
Yes.
What is the ability of a high school graduate to self-diagnose mental health abilities compared to yours?
In a high school graduate could know that they have problems, that they're depressed per se or sad. Not in all cases, because sometimes people come from such dysfunctional families that they don't know that they've been depressed all their life, because that's their only frame of reference. People if they're experiencing auditory hallucinations, probably have some understanding that this is abnormal. But again, being able to correctly diagnose what it is limited.
Self-diagnosis.
Correct.
Would other factors be involved in the way the questions are asked, who's asking the questions?
Of course, and it's also related to a person's self-esteem. If people have real positive self-esteem, they can, and they perceive mental illness as a flaw, and many people still do these days, acknowledging it would be another means in which their self-esteem is lowered. So somebody with very low self-esteem who's depressed would be much less likely to acknowledge another significant defective part of their being compared to somebody with higher self-esteem.
And the Wusthof records, 2008, where Mr. Bradley was there because of an automobile accident.
Correct.
Was there any indication that he was undergoing a psychiatric or psychological evaluation at that time? That information was collected?
No, just cognitive status.
Was there an indication whether he was in pain at the time?
Yes.
Was there an indication of whether he was under the influence of drugs at the time?
Yes.
And when information like that is gathered at a jail or prison, and you reviewed those records, any indication that Mr. Bradley was undergoing a psychological evaluation at that time, those times?
No, it would appear to be a screening.
Would there be, in your opinion, in your experience, in that setting, perhaps a concern, maybe in specifically Mr. Bradley's case, of not wanting to appear to be weak and vulnerable because of being mentally ill?
Yes.
There's a reason why, if there's a mental problem, you might not admit to it.
Correct.
Now, Mr. Bradley indicated auditory hallucinations.
Correct.
He didn't use those terms, did he?
No.
That's not like you said, I'm having auditory hallucinations. It's not, that didn't come out of his mouth, did it?
No, that was mine.
How did he relate that to you?
He was hearing voices.
At what points in his life?
Dating back to when he was in school.
Okay. Bench conference, please.
Okay, now we're focusing on the basis of your opinion of voluntariness of the statement and what informed that decision, what you rely on. And so part of that was Mr. Bradley's history you collected from him.
Correct.
And part of that was his report of having heard voices at points in his life.
Correct.
And would that have included when he was, like, when? School? When did he report that?
His ability to explain his past history of having these auditory hallucinations. Going back to his childhood is relevant and would add consistency to his present situation of having them as a child, even though he did not report it and even though it wasn't identified.
Well, if it's not in any of his schools, you got records from Cobb County, Georgia?
Yes.
School system, and Brevard County school system?
Yes.
And you didn't see any indication of that in either of those, right?
No, and I wouldn't expect to.
Why is that?
Again, 16 years in the school system, a guidance counselor, a school psychologist. If a child is sent to me and I make notes about it,
Okay, overruled.
I would have a cumulative file, but those don't go in the permanent records. And in fact, when you have a psychiatric disorder, as a school employee, that's not my role. We're not trained as psychologists or psychiatrists. we would refer that information to the parent and expect them to get the appropriate help.
Would you expect those types of records to be kept in either the Cobb County school system or Bard County school system, from the standpoint of an expert neuropsychologist and somebody with 16 years as a counselor in school systems?
Teacher and school psychologist. No, because what they keep is they keep transcript information. If the child is in special education, they would have their IEPs, and if there's any evaluations conducted, you would be very lucky to get those. Mainly nowadays when I request school records, I either get a series of IEP meetings and something like a high school transcript. We don't get those records.
Okay. Now, in part of your determination of the voluntariness of the statement of the waiver of Miranda, and you made a determination of the susceptibility to acquiesce, that is, to submit to an authority.
Correct.
And was your opinion on that as part of the voluntariness issue that you're asked to testify on? Did that include any aspects of Mr. Bradley's history that helped you inform that decision on the voluntariness and the willingness to acquiesce?
Yes, the evaluation for Miranda rights is a retrospective study, so yes.
Well, in particular, child abuse. Is that something that informed your decision, that you relied on in reaching the opinion that his statement was voluntary or not?
Yes.
In what way did that inform your decision?
It helped me understand the adult person, because our early childhood experiences provide the basic framework of our functioning as an adult, because that's the way the brain is designed. It's designed to work efficiently so that we don't have to reinvent the wheel each time we experience. So we have these automatic programs that we run that are formed throughout our childhood.
And what in particular information did you have that you relied on the issue of voluntariness?
Overruled. Based on the court's prior rulings, overruled.
As it relates to child abuse, you relied on?
His developmental history of being an abused child would impact his functioning as an adult.
Did he give you particulars about that?
He reported getting whippings and beatings by his stepfather. He reported trying to talk to his mother about it and wasn't able to have success, so he turned much more toward his friends and other family members, particularly his grandmother, and that's why her death was so impactful to him, to try to find a means to replace the nurturing that we expect to get from our parents.
From a chronological standpoint, the court relied on, did that time when he was getting the beatings and whippings, did that correspond with the start of the 12 of drug use that you described earlier?
Yes, it's the formative ages in which this happened, and going into middle school, where would be consistent those experiences of beginning auditory hallucinations, the beginning of using drugs for self-medication, commonly occurs in a child who's had that background.
Okay, and now, what is your opinion, based upon all of this information, you've considered as to Mr. Bradley's ability to knowingly, intelligently, voluntarily give a statement and waive Miranda rights?
Based upon the summation of all the data I obtained, I found he was significantly impaired at the time he reportedly waived his rights, such that his ability to know what he was doing, his ability to voluntarily do it, and his intelligence in making that decision were all significantly impaired.
And was part of that impairment based upon all you observed and considered and relied upon due to the ingestion of some sort of substance,
Yes.
in your opinion?
Absolutely.
Further questions?
Okay, it would be appropriate for us to take a break for the morning. We're going to take a 15-minute break. It's 10:30. We're going to be back here at 10:45. During this break, as the jury, you must continue to abide by your rules governing your service as a juror. All right, court will be in recess for 15 minutes.
All rise.
Okay, please be seated. Dr. Olander, you can take a break as well, and we will be in recess for 15 minutes as well. We'll be back here at 11:45.
Thank you, Your Honor.
Okay, thank you.